Chapter 18 is property management. In this particular section, we're going to be dealing with absentee ownership mainly, and why that became popular. Just remember that a property manager's job is to generate the greatest net income while at the same time maintaining the integrity of the property. In other words, you can't let it go to generate a high income. You've got to spend money to make sure that property stays in good repair. Let's talk about the license requirements. Just remember that if you are an on-site manager of an apartment complex working for an owner and that you're on a salary basis only, there's no license requirement. But anytime that you're receiving money in terms of compensation per transaction or perceived to be per transaction, a license is going to be required. Also, if you're working for a broker managing an apartment, you're going to have a license. As far as the property management market is concerned, it's a big market. We've got office building management, residential management, retail management, condominiums and cooperatives. A lot of people don't realize that the state of Florida has a lot of cooperatives that still are in existence in Florida. And of course the big one is the community association management. Community association management, what this is when we are managing associations, if you have more than 10 units in any number, whether it is together or separate, or if your budget is more than $100,000 a year, a CAM license is required. The rental process, you need to evaluate the rental market, see what's going on in the rental market. Is it up or down? You have to do a property evaluation, looking at the property to see what condition it's in. Rental unit marketing, I think, is also a big issue that you're going to have to address. Thematic image is something that is often tested that you need to remember. And all we're talking about when we're talking about thematic images, what about this property that's unique that you can draw on to do some advertising and marketing? So thematic image is a really good part of our marketing strategy. Tenant policy, just remember with a tenant policy, the best thing is to get everything out front, have a good conversation with the tenant, make sure they understand what the rules are up front, talk about it, things will go a lot smoother then. The various kinds of leases that we deal with, fixed leases, graduated leases, ground leases. Let me say something about ground leases. A lot of your commercial shopping centers, the out parcels are typically in a ground lease situation where you're simply renting the dirt. We've already talked about net leases, gross leases, and percentage lease. I do want you to know the difference between an assignment of lease and a sublease. And let me explain what the difference is. All contracts are assignable unless there's something in that document that won't allow it to be assignable. If I'm renting, let's say, a condominium on the beach, and I've got a year lease, and after 3 months I decide I don't want to be there anymore, and I try to find somebody to come in and step in and take my place, that's called an assignment. I'm giving up everything that I have remaining in that lease. Now, special note, just because I let somebody come in and assign my position doesn't necessarily let me off the hook. I may still be liable for the remaining part of that lease unless that landlord gives me novation from the agreement that I have with them. A sublease, on the other hand, is where I'm giving up less than everything I have remaining in the lease. In other words, if I decided to lease out or rent out one of my bedrooms, I'm giving up less than what I have. The various types of leases, and this is going to be important to you, to begin with, an estate for years or a tenancy for years. In my opinion, this is a true lease because by definition, this is a lease that, first of all, has a beginning date, it has an ending date, and it's in writing. Those three components have to be there. If any one is missing, it can't be a tenancy for years. And let me say this about a tenancy for years. It can't be arbitrarily terminated unless the tenant has breached. If one of these components is missing, what you might have is a tenancy at will. A good example of a tenancy at will is a month-to-month renter. If it's a month-to-month renter, you can evict that person with a 15-day notice. If it's a week-to-week renter, you can evict them with a 7-day notice. A tenancy at sufferance is simply a holdover. That's a person who has no agreement but still there. And let me give an example so that you can kind of put this puzzle together. You enter into a one-year lease. In the contract, it may say that upon termination of this lease, at the expiration of the lease, that the parties hereby agree to enter into a month-to-month relationship with a 30-day termination by either party. Well, what you're doing is that you're rolling a tenancy for years into a tenancy at will. Now, that clause is not in there, and the lease simply expires, but that tenant is still in there. That tenant becomes a tenancy at sufferance, and their termination can be immediate. There are going to be some maintenance issues that you need to deal with, scheduled inspections. I think that one of the important issues here is ownership management relationship. Anytime that you are a property manager, that you need to have a good relationship with whoever that owner is, and you need to know who they are. You need to know exactly how solid they are when you go to work there. The next big issue in the property management section has got to be the Residential Landlord-Tenant Act. And let me tell you what the most important part of this particular section has to do with. First of all, it does have to do with the relationship of landlords and tenants and how they're supposed to treat each other. But I think the big issue for us in testing is going to have to do with deposits, security deposits, and how that's handled. I think it's important for you to understand that a landlord can handle deposits differently than a real estate broker. If a real estate broker gets a security deposit, they have to place that in escrow. They can't do anything else with it. They can either put it in an interest-bearing account or non-interest. A landlord can do the very same thing. When they get a security deposit, they can put it in an interest-bearing account or non-interest-bearing escrow account. That's one way of handling it. But landlords can also commingle where brokers can't. Now, if a landlord decides to take deposits and put it in their personal checking account, they can certainly do that. But here's the rule. Now, there are some exceptions, but by and large, they're going to have to, first of all, pay their tenant 5% interest for the use of their money, and they're also going to have to place a surety bond or post a surety bond with a clerk of courts in the county that the property is located. Now, let me tell you what a surety bond is. A surety bond is nothing more than an insurance policy. That's all it is. So we can certainly commingle, or landlords can certainly commingle, but there's some caveats to that as well. When we talk about a termination of a lease, I think that it's going to be important for you to understand that if the landlord intends to retain any of the deposit for damages, they must notify their tenant within 30 days of termination by certified mail as to their intention. If they fail to do proper notification, they give up all rights to collecting any portion of that deposit for damages. And the last thing is breach. One thing that we don't want is for a tenant to breach, but if they do, you're going to have to take them to court. You're going to have to seek a writ of possession, is what we call it. That's what the 3-day notice is all about. You have to post it for 3 days. There's a legal process you have to go through, but ultimately what you're looking for from the court system is a writ of possession. The Civil Rights Act of 1866 says that we cannot discriminate because of race. In 1968, the Civil Rights Act also contained in it the Fair Housing Act, which simply expanded discrimination in the housing industry to include race, color, religion, sex, national origin, later handicapped individual, and familial status. That's families with children. And what this basically says is that we can't discriminate when it comes to being professionals in the business. Anytime that a licensee becomes involved in a real estate transaction, even a lease, there can be no discrimination. There are some exclusions. If I owned up to 3 rental units, the 1968 Fair Housing Act does not apply to me, but the 1866 Civil Rights Act still does. The Americans with Disabilities Act, simply an act created in 1990 to make sure that your commercial and public facilities would accommodate handicapped individuals. The statute of fraud, as we talked about earlier, says that certain contracts have to be in writing to be enforceable. And what that basically means is that in a lease, any lease for more than 1 year must be in writing, signed by the landlord. It doesn't have to be witnessed, and with all the formalities of any other conveyance instrument. Now, it's the landlord that has to sign it, or the lessor. The lessee is not required to sign it, but needs to sign it to obligate themselves to the debt of the lease payments. Leases for a year or under do not have to be in writing to be enforceable. The pure fact that somebody is paying you rent on a monthly basis and that's in a unit would tell any court that there's some type of agreement, which means that there'd be month to month with a 15-day termination. And that is all I have for you for Chapter 18, Property Management. So what I want to do now is I want to review with you those important topics. A property manager's job is to create the greatest net income while preserving the integrity of the property. A CAM license is required when managing more than 10 units in an association or the budget is more than $100,000. Thematic image promotes unique features in a property. Licensees are allowed to fill in the blanks of certain court-approved leases, but they cannot extend beyond 1 year. Assignment of lease gives up everything remaining in a lease. A sublease gives up only a portion of what's in the lease. The leasehold estates include a tenancy for years. Remember, it has a beginning date, an ending date, and it's in writing. A tenancy at will, a good example is a month-to-month tenant with a 15-day notice of termination. Remember, in a tenancy at will, one of those components of the tenancy for years is missing. A tenant at sufferance is simply a holdover. Termination can be immediate. The Landlord-Tenant Act. Deposits can be placed in either an interest-bearing or non-interest-bearing account. If you place it in an interest-bearing account as a landlord, you're going to owe your tenant 5% interest or 75% of whatever was collected. If you place deposits in a personal account, you're going to owe your tenant 5% interest, plus you have to post a surety bond with a clerk of courts in the amount of the deposit. A breach of a lease requires a 3-day notice of eviction and seeking a court-ordered writ of possession. The Fair Housing Act of 1968 prohibits discrimination based on race, color, religion, sex, and national origin. It applies to everyone in the housing industry. 1988 included handicapped and familiar status. Exemptions is federal and state retirement communities. ADA, the Americans with Disabilities Act, prohibits discrimination in commercial and public accommodations regarding handicapped persons. And that ends our review in Chapter 18.